Hello, everyone, and thanks for joining us this month for Side by Side Digital. I'm your host, Rebecca Shively. We've got a great program lined up today. This month, we're digging into transition planning and specifically some of the common legal pitfalls that can happen with transitions. We're joined today by Kitt Tovar Jensen. Kitt is a staff attorney at Iowa State University's Center for Agricultural Law and Taxation. She's going to walk us through some case studies, and we'll have some time at the end for Q&A, so be sure to submit those questions. Kitt, thank you so much for joining us today. I'll go ahead and turn it over to you.
Avoiding legal pitfalls and farm transition planning. Like Rebecca said, that's what we're going to be talking about today and how to avoid them. I have my contact information up here. Feel free to ask questions. I know there's a question box, like Rebecca said, and we can get to them at the end. If something pops up later, please reach out. We can talk a little bit more about it. But today, what I want to do is just look at some cases and situations that pop up and how some of these cases that we've had recently in Iowa, really some of these things that we want to avoid. We don't actually have clients at the center, but we do a lot of research, writing, education with the public and the agriculture community on these topics. And so we see a lot of this come up. We hear a lot of, unfortunately, some stories that family disputes, just these things happen. And what can we do to prevent them when we're thinking about the areas of farm transition, farm succession planning, estate planning, all those things. And these can pop up in a few different ways. Some of the things, this is a very technical area, right? This is why we want to use professionals like attorneys, tax advisors, insurance salesmen, all those different people that can help us get to reaching our goals. Other times, some of the cases we're going to look at, you might be thinking, well, Kitt, that's kind of common sense. I know that, but it's a good reminder too, because I'm sure a lot of these families didn't mean for their situations to end up in a court system. The fighting, the litigation, the expense that comes with it, and then the change family dynamics because of it. So we'll go through, look at these cases and just use them as a starting point. We don't know all the facts that went into this, but we'll be able to use them and hopefully learn from them. So what part of my job is I keep track of any new legislation, cases, regulations that come out that impact agriculture. And I look at a lot of the Iowa laws, obviously being based in Iowa. So that's what we're doing today. So I'm sure we have people from all over. I think these themes will be easy to understand and transferable to other states. But when I was looking through cases that have occurred in farm transition planning, I noticed that there was kind of three common areas. I actually used to be, before I went to law school, I was more of in a math science field. So I did my own little analysis and seeing what was popping up more, what was the most common issues. And the first one I saw was really disappointed beneficiaries. This is where somebody was very surprised what mom and dad did after they passed away. They did not think this was going to be the case. Maybe assets, the farm was divided differently than what they expected. Maybe there was some unspoken agreement they thought they had. And so people can be very surprised and upset when things don't always go as they were planning or as they anticipated. So we'll look at that in some ways to avoid having disappointed beneficiaries. The next section really has to deal with failing to plan. It's hard to talk about a lot of these topics, right? It can be taboo to talk about death, finances, and it might be easier to just not think about it or say, I'll get to that someday. I don't need to do it now. But there can be a lot of issues that pop up if we don't plan at all, if we don't plan with the right help. And we'll look at some of those cases as well, what happens when if we don't have a plan. And then lastly, this is kind of a big one that just popped up, kind of a catch-all, was just life events. People don't seem to account that normal life events are going to happen, and they can be good things like marriage and birth, but also things like divorce, death, disability, just fighting. These are things that happen in life, and we just need to prepare for them, especially when they're good things too. We just need to be aware that they're going to happen to us, to our family at some point, one of these things, and making sure we're reacting accordingly. So we'll go through and look at some stuff from each category. But I want to start off talking about these disappointed beneficiaries. We're going to look at some cases with wills in them. You all know what this is. A will is just a document that lets you allocate your property how you'd like to after you pass away, right? That's pretty simple. So to have a valid will though, and this is at least in Iowa, the law says that your will is valid if it's in writing. So it can't be holographic, it can't be a verbal promise or in video or something like that. It has to be written. The testator, that's the person making the will, they have to sign it. And then there has to be 2 witnesses. Now, if you're looking at these 3 things, you're thinking, well, how come there be that much fighting if that's what all it takes to be a valid will? And it really is this last thing, this testamentary capacity. Did the testator making the will, did they have the ability, did they have sound mind to make the will? And that is where we see the most fights. And it's not necessarily a very high standard, but when there is a disappointed beneficiary, usually what they're thinking is that, well, mom and dad, they could not have had testamentary capacity. My siblings must have used some sort of undue influence. They must have taken advantage of my parents' lack of testamentary capacity and gotten them to change their will to favor the sibling over me. And so that's where a lot of the lawsuits come up, is this testamentary capacity, undue influence type of claim. And so with testamentary capacity, again, it's not a medical standard, it's more of a legal standard. And lawyers, judges, they're not doctors. They're not trying to be doctors and do an IQ test or anything like that. They're just trying to make sure there's no red flags and this person was able to do this, had the legal ability at the very least. And so when courts are looking for testamentary capacity, they're looking at things like, did the testator understand what this document was, that it was a will, that it was going to distribute their assets after they passed away? Did they understand what they owned? Is there some type of red flag here that, this does not mean that the person who passed away, they have to know the exact amount of money in your bank account or the exact amount of acres that you own. Just, is there any red flags here that they were trying to give away the neighbor's land, something strange like that, that just shows that there were some issues. This third thing then, natural objects of your affection, it sounds a little strange, and it usually means things like close family, friends. That's generally who you would think of, you have natural affection for. This does not mean, however, that you have to include your kids, you have to include your family. We'll see at the end, it's very difficult to disinherit your spouse, but besides that, you can favor one child or the other. You can decide to do or give everything to charity, things like that. It's not so much here that we're looking at what we would do, because maybe we all have different opinions, but is there a valid reason that someone maybe would want to give everything to charity over their kids? We might not do that, but some people might. So that's a natural object of your affection. Then finally, do they understand the effect of this, especially if there's some type of unfairness going on, or what we would consider unfairness? If you are favoring one child over the other, attorneys want to make sure you understand that, because even though you can, we want to prevent any undue influence from occurring. And so if someone does decide to favor one child or the other, something like that, they may take extra precautions. Just to give you a heads up. They may record the interaction just to show that, yes, they had no really red flags about this. You can explain your reasoning. They may ask questions. What's the year? Who's the president? Things like that, just to show that there was no red flags that any of these issues had popped up. So that's a little bit of our primer. And I want to look then at our first case about disappointed beneficiaries. So what was going on here? There was this couple, they owned a farm, they farmed together. After the husband passed away, she updated her will. Originally, everything was going to her spouse, but after he passed away, she updates her will and says, what I'm going to do now is, we have 2 kids, a son and a daughter. They're each going to split it equally. They're going to split everything right down the middle. So that's what they have their will. She has it like that for many years. About 15 years later, she does suffer from a stroke. Her daughter had already moved home at this point and begins to take care of her, becoming pretty much her primary caregiver. She ran errands for her, took her to the doctor, picked up her medicine, everything like that. Her son at this point is starting to farm. He is renting the farm from her. He's doing quite well for himself. And so more than a decade goes by. And in 2015, the testator, her goals had changed. She decides, I'm going to update my will again. I am going to leave everything to my daughter. And she explains her reasoning for it in this will. She says that I am going to deliberately leave out my son as a beneficiary. I have no bad feelings against him. It's just that my daughter has a greater need for financial need, and she has taken care of me for so long. Because the son had done well for himself. He'd gotten married, grown the business. His sons actually farmed with him. So this woman's grandsons were on the farm helping. The daughter, on the other hand, she had helped. And we actually have spreadsheets on this that can calculate how much a sibling, a child, a family member can save the family, really help them in a financial way by taking care of a parent or a family member. The cost of having in-home caregiver, someone to come, deliver medicines, anything like that, it can really add up. So it might not always seem like it's a financial sacrifice, but it has a big financial impact on them, on the family. So the testator, she updates her will, and then the following year, she passes away. Unsurprisingly, there's some issues, I guess. The son is not quite accepting this will. So once someone passes away, what you're supposed to do is submit the will to the county clerk at the courthouse and get the probate process starting to get the assets going to the heirs, to whoever the beneficiaries are. So the son, he says, well, there's no way that will is right. I'm going to submit the old one where I got half. The daughter says, no, this is the right one. So they both submit one. While that's being figured out, the siblings, there's co-executors of the estates. They're both trying to manage the farm. They're both trying to get the estate to the probate process. And again, not surprisingly, they have some disagreements, right? They are not able to get along. And the son eventually does file a lawsuit. He says, my sister must have unduly influenced my mom. She did not have testamentary capacity. And so the most recent will, the 2015 will, it's not valid. It's daughter at the same time files her own lawsuit saying this was the right will. And the court kind of combines the cases in this family fight. So what happens, this case, it goes to the jury, and the jury says, no, this will, there's not enough evidence that this was a result of undue influence. This is a valid will. And we only see the outcome. We don't actually get to see the jury reasoning behind it. But so I kind of made my own little scoring system here again, where some things that seem to definitely play in favor of the testator. She did a lot of things right. First off, she updated her will when her life circumstances changed, right? When her husband passed away, she was updating her will. That's what you need to do when some life event happens. We'll see that at the end. We need to make sure our estate plan is updated. I also gave her a bonus point because when her goals changed, she updated her will. There isn't a right or wrong answer necessarily when it comes to estate planning, farm succession planning. But here, when she decided that a goal of hers was to say thank you to her daughter in a way, she had changed her will. So she updated it again. So we give her 2 points for that. And even though it was the year before she died, and that just shows that there's no point in waiting, right? You never know what's going to happen. So when things change, make sure we're updating our plans. Next, she also did write her reasoning for the change in the second will. She explained it. It wasn't a case of, oh, did someone just forget? Because we have seen cases like that where the youngest grandchild is not included in a will. Is it on purpose? Is it not? That type of thing can be argued. Here, she said, I am intentionally doing it. My goal, what's important to me now is to help my daughter out after all she's given me. So we give her a point for that. Next, I kind of give her a neutral score because we don't know the full story here, I don't think, whether or not she was communicating, because a lot of the time where beneficiaries are disappointed is because they were surprised. Here, it said the case says that she talked to her grandsons, so her son's sons who were helping farm. She talked to them about this goal to leave the farm to the daughter. She told her daughter. We don't quite know if she told the son, but she was at least talking about some way. Could she have implemented some family meetings, things like that at some point? Maybe, but I think this was at least a neutral, that she was open about it to at least some people. So here are some ideas to avoid litigation. We don't want to wait to make any changes, right? If we know that something has changed and we want to make a change, some life event, anything like that, don't wait. Make your plans. There's no point in waiting until the last minute. It can just be more complicated, more messy. Just get it done, even though nobody likes paperwork, I know, but I'm gonna encourage you all to not put it off. Then a big thing too, this is more the practical thing, just remember to communicate. Even though talking about these things like death and finances can be very taboo, you need to make sure your wishes are known to your family. So make sure you're having these family meetings, family discussions, so that down the road we can prevent fighting or any type of surprises. Then I would also encourage you to, if you have a family dynamic where you're nervous that things are just, there's going to be some fighting and you want some help, there are third parties, there are trained mediators. The Iowa Mediation Service, for example, they do have a full farm service division that can help with mediation in farm succession planning, getting everyone together, especially if you're still you're still mom and dad holding some control. You can say, well, you need to do this. And it can be a preventative thing. It can be hard. We probably have some family members that are easier to discuss unpleasant things with than others, but just consider this. I'm going to keep moving. And so that was our disappointed beneficiaries section. I want to look at some cases now that deal with failing to plan and what happens then, because it can be a situation where people, they like to, it's easier to almost stick your head in the sand than acknowledge some of these things. It can go both ways too, because I have talked to people who say, I'm trying to talk about my plan, but my kids say, you know, Mom, you're never going to die. I don't want to talk about it. So it can be hard, but we don't want to not plan at all. That can cause some big issues and create a mess. And we also want to make sure we have the right help and we're doing planning, knowing our family's specific situation, having that in mind. So make sure that we have the right team in place, all those different things. So what happens if you don't plan at all? Well, that is actually a plan. The state will have a plan for you then, and it's probably not the best one, even though they're trying to get things right, but there's these things called intestacy laws that if you don't have a plan in place, the state has one for you. And it can be a very messy situation if it doesn't take into account several things with family businesses, right? So it can create a mess for your heirs. And this is a time when, you know, we're really focusing on the legal side of things today, but practically what's also going on is losing a family member is a very tough emotional time too. So it is just something that we want it to be as smooth as possible for our loved ones. So what intestacy laws are is, or what intestate means, I guess I should start there. Intestate means that someone passed away without a will, trust, any type of written plan. And I thought this was interesting. It's actually about half the US population, about 46 to 47% of the US will pass away intestate with no plan at all. And so this is sometimes called an estate plan by default because the state, it might vary a little bit, the laws from state to state, but they have a set of rules on how your assets and how we're going to pass on to your heirs and who is going to get it, who's going to be the beneficiaries then. And they are trying to get it right. They start off with the closest degrees of kinship, they call it. So if you pass away and you are married, everything goes to your spouse. If you're unmarried and you have 2 kids, everything is split evenly amongst your kids. So it starts off very close like that, and it will start to slowly get wider and wider, you know, goes to brothers and sisters, aunts, uncles, grandparents, cousins, second cousins, until eventually the state kind of cuts it off. They're not going to do a search anymore. And they say everything is going to escheat to the state. So everything's going to the state if they can't find anybody. So again, the state's trying to get this right, but it really doesn't take into account things that can be very common nowadays, like second marriages and blended families. People can be just as close to their step family as their biological family. It also doesn't take into account family-like relationships. I had talked to a couple who owned a farm. They did not really have any close family around. So what they wanted to do is that they had a very close relationship with the two tenants, the young couple who was renting from them. They were close with them, but if they didn't actually make a plan, all their assets, the farm would go to the state, would not to the couple, just because they had idea to do it, they would like to. The state won't let that happen. They will use this formula, these laws to, if there is no plan in place. So this brings me to my next case then, about an attempted land transfer that did not go according to plan. And so in this case, this is another Iowa case. There was a couple who, according to the case, was really wanted to avoid probate. They did not want to work with attorneys. And so what they try to do is say they owed the land as joint tenants with the rights to survivorship as a married couple. And they say, well, we're going to keep this land now. We have all rights of ownership. But at the same time, we're making this deed on our own that says, but our kids are going to have all rights, but those don't go into play until we pass away. So they try to do this. The husband, he passes away, and the wife, she tries to update it. She says, well, some things have changed. They have 3 kids who they were trying to deed everything to, or upon death. But one of her 3 kids had some type of health issue. So she was on government assistance. And so the wife, she's concerned that the state government may do some type of clawback at the farm. And her goal is to keep the farm in the family. She says, well, this is what I'm going to do. I'm going to make a new deed. I'm having all rights of ownership while I'm alive. Upon death, 2 of my kids, or not the full 3, my other daughter and my son, they are going to be able to have it once I pass away. She said, I have no bad feelings against my daughter, but I just want to make sure the farm stays in the family. So what happens, this daughter with the health condition, she passes away, but before she does have 3 kids. So there's 3 grandchildren involved. And I know this is getting a little bit messy. So I try to make a family tree here. So the daughter with the health condition has passed away. The mom, now grandma, she also passes away. She has no will or trust or anything like that. She just has this deed. And so the 3 grandkids, they know that grandma had done this. They thought they did not have any interest in the farm. But for some reason, a utility company buys a little section of the land and they see, oh, this is not, I don't think this is a valid deed. There's no will. So we're going to give money to all the heirs of grandma because it was intestate, which would be son, daughter, so the aunt and uncle, and then the 3 grandkids. So that's where this mess in this court case this is how it occurs. The 3 grandkids then say, well, I do want to have a share then if I could under intestate laws. So this goes to trial and the court's trying to figure out, well, do the grandkids have right to the land? Did they inherit under intestate laws, or was this deed valid? The Iowa court says no, this was an attempted transfer on death deed. But at least in Iowa, transfer on death deeds are not valid. I believe they're valid in Missouri. I don't know about Nebraska, but because in Iowa, we do not allow this, the farm has to pass through all the farm assets, and all the assets, grandma's assets, have to pass through intestate laws. So I divided it out here. You can see the son and the aunt and uncle each get a third. Then the deceased daughter's third, it gets divided up around her 3 kids. So they each get a 9th. So that is how it played out in the end. And some of you might be surprised because there is actually 30 states that do allow transfer on death deeds. This was just a technical error that the couple did not know about. The grandma, she was unaware of. I was just not one of them. They've talked about it. It has not happened. So, and in this the outcome might be something that, well, the grandma wanted the farm to stay in the family. It did, but all the work that went into all the fighting, I have to think that it changed the family dynamic between the nieces and nephews and aunt and uncle. It gets to be a messy situation. So this is what we want to be avoiding. Because how I like to say, help me is less expensive than fix me, right? Preventing it, even though it can be not fun to have to front these costs at the beginning, to have a successful farm transition, you just need to have this team in place of advisors to help you reach your goals, whatever those are. There's things like Legal Zoom, but it's not the place to try to use them. It feels like we can find all the information we need on the internet nowadays, but this is just one small thing where transfer on death deeds, they work in some states, just not the state that we were in this case. So make sure you are working with attorneys, tax advisor, whoever it is that has experience working with succession planning, working in probate, estate planning, all of that, and that they understand farm operations, that they know how the family dynamics can come into play, all those different things that change when it's a family business, not just not pure assets. There's an operation going on as well, and a lot more emotion tied to it, honestly, too. Because succession planning, it really is a family member or a family matter, excuse me, and a big goal that we maybe think of our operation in certain goals we want to hit, and it might not be the front of our brain, but I think we all can agree we want our family to be able to get along. We want to be able to have a good relationship with our siblings. We want our grandkids to grow up doing holidays together. So make sure that you are acknowledging maybe differences in goals in your own family. Is there an on-farm heir and off-farm heir? Do you have several children interested? None. We want to make sure this the family dynamic side of it is also being addressed. And so that's why we can have these conversations with everyone that needs to be included. Then lastly, I want to talk about life events. These are things that just we know can happen. And that if they haven't happened to us, they happen to someone in our family, someone that we know. Marriage, right? Some of these are good things. Marriage, and some of them are not as good. Divorce, disability, especially early disability, and unfortunately it happens. This can be a dangerous operation, so we want to be aware of that. Is there death? Unfortunately, this is something that we need to prepare for. Family disagreements. Is there a way to address things that happen down the road? If somebody wants to get out of the family farm, are we prepared for that? We want to plan during the good times so that the bad times aren't as bad. Births, these are all things, like I had mentioned, the grandkid accidentally left off a will, the youngest one. These are all things that happen and we want to be ready for. So, and here's a case that happened with, we'll talk about marriage first, which again is supposed to be a good, happy thing. I heard that 2022 has the most weddings since like World War II or something like that. So there's a lot of marriages starting right now. But what was going on here, there was a young guy that he farmed, and in his 20s or so, he made a will that left everything to either his parents, or if they were not alive, his brother and sister. So that's what he did. He made the will. He did the right thing, right? That's what you're supposed to do. By the time he passed away, the main asset that he owned, the most valuable one, was the farmland. So he made this will in his 20s. In his 40s or 50s, he got married. He just never updated his will though. And then when he passed away in his 90s, so he'd been married for 40 or 50 years, his wife did not get anything under the will. It seemed like an accident. To read into this, it seemed like it was an accident. So in Iowa, we have this thing called the elective share, where this surviving spouse who is not named in a will or trust or any type of estate plan like that, they are still entitled to a third of the deceased spouse estate. The only way out of this and around this is if you have a valid prenup. So a prenup can negate this, but in general, the idea is that we don't want spouses accidentally disinherited. That's a government objective. So what had to happen, the case is about the valuation of the farmland, because they had to figure out the value of the farmland to make sure the surviving spouse was able to get her 1/3 share of the estate. But they were able to do it, but you have to imagine this was it was very hard. Someone loses their partner 40 or 50 years, they have to go through this. They knew their brother and sister-in-law, and they had to try to figure out the valuation, ask for this. It doesn't say that they were fighting or anything like that, but it has to be a very uncomfortable time. And so that is why planning ahead, doing these things, thinking about these uncomfortable topics, it's very much a selfless act to have it in place so that when you're gone, there's not the issues that, there's issues that we prevented. Because when do these things pop up is when, when is there disputes about undue influence, testamentary capacity? It's once the person has passed away and they're not there to defend themselves anymore. So we want to take care of as much of this as possible. So what about divorce then? Well, just so you know, in Iowa at least, if a person gets divorced, if a couple gets divorced, the state's going to assume that you no longer want that ex-spouse to be a beneficiary of a trust or will. However, that is not true of all states. So be careful of that. And that's also not true of all retirement tools or succession planning tools. Retirement accounts, life insurance accounts, they maybe will not always, if you get divorced, they will keep that beneficiary there unless you change it. So that's why we want to be very careful of beneficiary designations, because really everything has one. Everything we've talked about, all the tools for succession planning, estate planning, life insurance, retirement accounts, trust wills, the big ones, everything has one. And a big issue that pops up with these beneficiary designations is just forgetting to even name one. It happens where someone, 22-year-old, gets their first job that has a 401k or something like that, and they've just never thought to update it. Well, make sure you have this beneficiary named, that these things that you have worked towards, the life insurance, whatever you've done to make life a little bit easier for your family and loved ones, that it gets to them, right? So I'm just going to encourage everyone to yearly, this is not a whole update your estate plan every year, just every year, let's make sure our beneficiary designations are still up to date. Maybe around the beginning of the year, maybe your taxes, your birthday, something like that. Just think, well, was there a marriage, a birth, a death, divorce that I need to update something? Because it shouldn't take longer than 15 minutes just to think, does anything need to be changed? Because most of the time you won't, but just remember that. Also double check spelling. This is another issue I've heard has come up. I know for cases, someone like me, so everybody calls me Kitt. My legal name is Catherine, and there's 1,000 ways to spell that, right? So just make sure we have that. So the the life insurance company, for example, they're going to try to find the right person. We just want to make it as seamless and easy as possible for our loved ones. So that was a lot, but so now what? First off, we have a lot of great materials on our Ag Decision Maker website, AG Decision Maker. We have something like an estate planning questionnaire to start. You can make an inventory. That's what the attorney is going to be asking for. What do you own? What are your goals? Figure that out. What do you want to do? Do you want to bring on an on-farm heir? Do you want to leave some type of legacy with a charity? Anything like that. And make sure your family knows about your plans. It's up to you, and it can be hard to talk about them, but it's best because you want to plan things with their ideas in mind too, or knowing things. Maybe two siblings do not want to work together. They do not want to own land together. We can take care of things earlier rather than later. So then get those team of advisors together and then actually implement your plan. So whatever that is, and it maybe will change. This is maybe sometimes a repeat process, but this is kind of the basics of it. So are there any questions then?
Awesome. Thanks, Kitt, for sharing some really interesting case studies. You've probably seen the whole spectrum of things. And just a reminder, you can submit those questions using the Q&A. It looks like we have a couple that have come in. One, you talked about the importance of assembling your team and getting the right people and not relying on the internet for advice. Do you have any advice for kind of young people who maybe don't have those connections? How do you find an attorney and someone who might be a good resource, and how do you kind of vet that person out to make sure it's a good fit for you and your operation?
Mm-hmm. Yeah, that's a great question. One of the best ways to find someone to help you with an estate plan, a lot of times it's word of mouth. I know that can be uncomfortable sometimes, that don't really want to tell someone what you're necessarily looking for, what you're doing. But if there is a trusted person, you know, that they just did their estate plan, they were talking about, well, who did you go to? Anything like that. If you are working with someone who does your taxes, is there anyone they recommend? Something like that. If you are kind of striking out on the personnel strategy, there is also some good websites. Like there's one in Iowa called Iowa Find a Lawyer. That can be very helpful to at least start your search. You can narrow down by geographic locations or legal or like topic area. So you can look at things like agriculture and probate. That can get you started. And so these attorneys, they offer free or low cost consultations to at least let you know what they want to do. Or if if they're very busy, they can't take you on, or there's a conflict of interest, something like that, they will at least know the right person. In general, when you're actually talking to someone, it might take a few different tries to, meet the right attorney that you feel comfortable with, the right tax advisor, because make sure you are comfortable with them. You can ask questions, things like that. You're going to want to make sure that they work in this area. You don't necessarily want someone that specializes, for example, in criminal law or divorce. You want someone who, and some attorneys do, especially in more rural areas, they do a lot of things. But if they have not done, ask how many clients they have that they've done things like this for. That can be a helpful way to start it. And if you have to, try a few different people, it's worth it. I know some people will joke about how they've inherited their parents' attorney. They're like, well, he did my grandparents' will, my parents' will, now I have to. And that can work just fine. But you can also feel free to look around and see if there's other people like that. So, and a lot can be done online now too. So that's very convenient.
Yeah, I'd also throw out, if you're working with someone from Farm Credit Services of America or Frontier Farm Credit, your financial officer or insurance officer, those are folks who obviously work with a lot of farmers and ranchers and have good connections too. So asking one of those folks that you work with for a referral, can't go wrong with that. A couple of questions have been coming in. As you start planning, do you start with the biggest assets or start with kind of the easy things first when you're working on your plan? Do you have a recommendation for kind of getting started? What order?
Yeah, that's a good question. And I don't think I've ever been asked something quite like that before. It depends. That's the answer everyone loves to give. But if you can, I would start with developing your goals first. There's some big picture items like the will, the trust that need to transfer assets on. So I would get goals together, your inventory together, and then working with the attorney, because you're going to have to, I guess I'm thinking of small items like a power of attorney. There's kind of these hodgepodge of things that come along, maybe a living will, healthcare power of attorney, all different things like that. So you kind of want to get them done all at once at, more or less. The big ones, people usually take a little bit longer. Who's going to get the farm, stuff like that. But those little things can be just as important too, trying to figure out, final funeral arrangements, things like that. So it kind of gets done all at once, more or less. But I would start with goals because you don't go into an attorney's office and say, I want an LLC. You kind of go in and say, well, this is what I want to do. What tool will get me there? So goals would be the good first step.
Great, good advice there. Another one that came in, do you have any advice on transitioning a farm corporation that involves more than one owner?
Okay. So that can be a tricky process. So I'm guessing this is either I don't know if it's an S Corp or C Corp, and I'm not sure what you're transitioning into. But again, these are some things that take time. So there's really no point to wait, depending on what you want the corporation to become. These things can take couple years, which isn't always the end of the world, but there's really no point in putting it off. But just make sure that if there's multiple owners, everybody's on board. If you're going to talk to an attorney about switching your S Corp or C Corp into something else, get those documents, that the bylaws, whatever you have, the beginning documents that control, because a lot of times people will call and ask me a question and I'll say, well, what does your articles of incorporation say? What does this say? And so you have to find those first, because that actually might limit or tell you what your options are. So, but yeah, I know that's vague, but that's kind of where to start, is finding that document.
Great, and this one maybe similar, maybe builds on it, but you had mentioned the 1/3 elective share that goes to the spouse if there's no will. The question here is, would that only apply to assets personally owned? What about those held by an LLC or corporation? What if that entity was 100% held by the deceased person?
Mm-hmm. So if the deceased spouse has no will, no trust, no anything, then everything will pass through intestacy laws to the spouse. If they have a will that does not include their spouse, that is when the 1/3 elective share comes in. And so they really look at the value of the estate. And that might be a more of a CPA question, how you value certain personal items. I do not know if it deals as much with that personal things, usually, again, everything would go to the spouse. If there is no will, if they're just accidentally not included, that would change things a little bit. And the valuation, I'm not as sure about for personal items, but it does include the entire estate of whatever they have, LLC shares, or stock, business holdings, anything like that.
Great. I know you had mentioned that idea of making an initial investment, talking to someone, and kind of that's sometimes hard to do, but better than kind of the costly litigation on the back end. Are you able to share, like, kind of ballpark some of those cases, kind of what that might look like if you did get into that situation?
The cost.
Yeah.
And I don't get to actually see costs. You can see filing fees, things like that. I have heard so I don't know exactly. I do know that there's a rule of thumb that just to get to trial, the district court, so, we have 3 court levels in Iowa: district court, Court of Appeals, Supreme Court. Just to get to the district court sometimes can cost about $10,000. And then that doesn't include getting through the trial and everything that's going to cost that. So that's just your attorney getting ready, deposition, interrogatories, anything like that. And then there's all the court costs with it. And I have seen things then where people go, you have to start in district court no matter what. And then maybe they'll bounce around in Iowa. They'll go to the Court of Appeals, Supreme Court, Court of Appeals. And, it could be hundreds of thousands of dollars in litigation. And sometimes it becomes more emotional, where unfortunately people just want to be right. But it can be add up really fast, and it's something. That's why I like doing this type of thing, where it's hopefully we can prevent it and not run into something like that, because it can add up really fast.
Yeah, so it sounds like definitely well worth it to maybe pay a couple $100 on the front end to have those conversations, talk to someone early, maybe bring in a mediator if it's a difficult conversation, but sounds like it's definitely better than the alternative of trying to clean up the mess on the back end.
Right, exactly. And some things you can't put a price on, like just families getting along. So that's a great point.
Definitely. Well, it looks like we're just about at time here. I'm not seeing any other questions in here, but Kitt, if you could have one piece of advice that you'd want to leave kind of our listeners with today as they're thinking about this, what would you like to leave the audience with?
I would say this is something that I would not wait on. If you could all today just think of one thing you're going to do to get you ready. Is that you're going to search for attorneys, you're going to make that inventory list, or just talk. You say, I have a plan, I just haven't told anyone yet. If you could make one actionable thing today, I think that would be great. Just don't wait on it, because you might have to change everything a little bit down the road, but once the main pieces are in place, it's going to take a lot of headache and stress away from you, and hopefully your family. So.
Yeah, really good advice. I think definitely starting early and not being afraid to use the resources available. So definitely reach out. Your financial officer is a great resource. We have access to really great experts here at Farm Credit. We have partnerships with Nationwide, with New York Life, to set you up with folks that can really help you navigate some of this. So great conversation, really interesting examples. Kitt, thanks so much for sharing them and joining us this month. Thank you everyone in the audience for your participation and great questions that you sent in. Kitt has some great additional resources on here, so definitely be sure to check those out. We'll be back next month on June 1st. We'll be digging into technology a little bit and how to prepare your family farm for the future state of agriculture. So that should be a really cool topic. So we hope you'll join us again on June 1st. Until then, take good care, and we hope to see you online soon.